Hey everyone, Harry here to talk about a amicus brief, a brief filed not by the parties urging the 11th Circuit to recuse Eileen Cannon in the event they reverse the holding of Cannon to dismiss the case against Donald Trump on a pretty crazy theory that has very little basis in precedent, and that gives Trump the latest and greatest of the many breaks Eileen Cannon has afforded him. Recall, Judge Cannon's latest in a long line of really flagrantly pro-Trump moves was her granting of a motion to dismiss the entire case based on a theory that no other court has adopted. And when I say no other court, we're talking about 50 years of other courts dating back to the U.S. Supreme Court in the rock-solid precedent of U.S. versus Nixon. In the face of all this authority, Judge Cannon held that the special counsel here, Jack Smith, had not been appointed according to law. What that means is that Congress hadn't authorized it in the way that they authorize executive agencies to hire different people or undertake certain actions. There are 3 different statutes that the special counsel has pointed to say, here's where Congress granted us authority, here's where Congress granted us authority, here's where Congress granted us authority. Each of those Judge Cannon didn't like and gave a sort of twisted or tortured analysis to say, no, that doesn't do it. And remember, of course, this is all first surfaced in a odd concurring opinion by Justice Clarence Thomas in the U.S. Supreme Court in the immunity case, saying, maybe there's some issue here that doesn't even say, as Thomas usually has no problem doing, that this is definitely a problem, but just sort of thinks maybe there is, and it becomes a script, or at least the bare bones of the script that Cannon authorizes. Okay, so it was long before then that people were beginning to think that something is really rotten in Judge Cannon's court, and I among them. She's done so many things so out of step with every other court and so pro-Trump and anti-government too, always sort of slapping the government around. You had a trouble not coming to the conclusion that she was really in some way in the tank and not really thinking about the law and facts, but thinking about the former president and possibly president-to-be who had put her in office as among the last judges he had appointed. All right, so she dismisses this, and over the course of months, while she's been giving the government a hard time, she's often stepped back from actually holding the government had acted wrong or denying some motion of theirs that gave them a purchase on an actual appeal to the 11th Circuit. That mattered because at the very beginning of the case, as you may remember, she had made several blunders involving the initial search warrant and gotten the whole case completely off track with a special master and all kinds of evidentiary rulings about privilege that just wouldn't do in a normal search warrant case. Government collects the evidence and then they use it at trial subject to some arguments there. All right. When she dismissed the case, though, it seemed to everyone, okay, finally, the government has its opportunity. It's a very suspect opinion. That understates it. It's very unlikely to survive the 11th Circuit. But what about Eileen Cannon? So when Jack Smith filed the special counsel brief for the DOJ in the 11th Circuit, people looked immediately to the last page. Was there some final section saying, if you reverse, you should recuse Judge Cannon based on the law in the 11th Circuit? And the law in the 11th Circuit is a pretty high hurdle and involves, a couple possible things. But one of them is a series of blunders or of rulings in favor of one party that give rise to a reasonable doubt in the public about her impartiality. So combined with what she had done before, this pretty flagrantly off-base motion to dismiss seemed to really set up the actual recusal. So, to a lot of people's surprise, Jack Smith and the DOJ did not ask for recusal. And the typical way to do it would be in a simple kind of addition at the end of a brief. There are still other ways potentially to do it, but you can't raise new arguments in a reply brief. And at oral argument, if the judges ask the DOJ, what's your position about recusing? Obviously, you provide an answer in response to the court, but if they don't, it's not clear that you can just get up on your soapbox and say you have to bounce her. Possibly. And possibly that's their strategy. But it really struck people, why haven't they served this up? Because recusal, it takes a certain measure of gumption and force by a court to actually bounce one of their, a sister judge in the lower circuit. And the Department of Justice calling for it would really, I think, stiffen their spine to be able to do it. Whereas now they are totally out on a limb. And that's what this brief is about. So you have a retired federal judge, Nancy Gertner, some very eminent ethics experts, and they do what the DOJ did not. They march through the law in the 11th Circuit, and there's a 3 or 4 factor test under a particular case. And they, I'd say this factor's met, that factor's met, the third factor is met. And so they have the force of their own prestige, but they're not parties. And there's no requirement even that their brief be accepted. Technically what's happened is they've written a brief. This is how the process works. Put a motion on it saying, please accept this brief just as a friend of the court. And it's up to the court whether to accept it. They probably will accept it. And it puts the recusal prospect in play. And that's why they're doing it. It's a pale second best to the actual party whose ox is being gored, the DOJ, saying, get her out of here. Here's all the ways that she's really not delivering justice to us and the justice system overall. It's just a friend of the court, well respected, but a friend of the court. So, if they accept the brief, there's nothing fancy in the argumentation. They just march through the different factors. It's short and to the point, but at least it will put into play the recusal notion, and it will likely call on the 11th Circuit to consider the analysis. And the worry is without it, they might not even, because the DOJ hasn't called for it. So that's the state of play with the amicus brief in the 11th Circuit. Filing is still midway. This is around when Trump's brief will be due, then a reply brief, and they will hear arguments later in the year or so. So at least there will be in front of the 11th Circuit some effort to analyze and advocate for the recusal of Judge Eileen Cannon, who really has been very slanted in her rulings and whole administration of the case. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.